Imagine waking up one morning and seeing headlines saying immigration protections could change in 2026. For many immigrants in the United States, that kind of news creates fear. Questions start running through your mind. Is my status safe? Is my family protected? Are naturalized citizens at risk? Is something big about to change? Right now, a major immigration issue is being pushed toward the United States Supreme Court. And whenever the Supreme Court is involved, people assume something dramatic is about to happen. But here's the truth. Legal review does not mean immediate policy change. In early 2026, the federal government asked the Supreme Court to review certain immigration protections, including temporary protected status, also known as TPS. TPS allows individuals from countries facing war, natural disasters, or humanitarian crises to live and work legally in the United States for a temporary period. This protection has helped thousands of families build stability in America. Now, because of legal disagreements, the future interpretation of some protections is being reviewed. And that word, the reviewed, is very important. It does not mean canceled. It does not mean removed. It does not mean immediate deportation. It means the court is being asked to examine how the law should be interpreted. But here is where confusion spreads online. Some social media posts are claiming that citizenship rules are changing. Others are saying green card holders are at risk. Some even claim naturalized Americans could lose citizenship. So let's slow down and separate facts from fear. Right now, this case is about legal interpretation of specific protections, not about stripping citizenship from lawful Americans. If you are a naturalized citizen, your citizenship is protected under federal law. Revoking citizenship requires extreme circumstances, such as proven fraud during the application process. There is no broad order targeting lawful naturalized Americans. That reassurance matters, but why is this case important then? Because Supreme Court decisions can shape how immigration laws are applied nationwide. Even if changes are narrow, they can influence future policy direction. And that's why people are watching closely. In this video, I'm going to explain what exactly is being reviewed, who could be affected, who is not affected, what realistic outcomes look like, and what you should actually do right now. Stay with me, because in the next part, we're going deeper into TPS and why this issue reached the Supreme Court in the first place. So now let's understand why temporary protected status, or TPS, has become such a major legal issue in 2026. TPS was created as a humanitarian protection. It is designed for people whose home countries are facing war, political instability, natural disasters, or extreme humanitarian crises. When a country is designated for TPS, eligible individuals from that country can legally stay and work in the United States for a limited, renewable period of time. It does not automatically give a green card. It does not automatically give citizenship, it is temporary protection. Over the years, TPS has been extended multiple times for different countries. And this is where legal disagreement begins. Some policymakers argue that long-term extensions go beyond the original intent of the law. Others argue that humanitarian conditions in certain countries have not improved enough to safely return people. Because of this disagreement, lawsuits were filed. Lower courts made decisions, appeals were submitted. And now the question has reached the Supreme Court level. But here is something very important to understand. The Supreme Court has not issued a final ruling yet. In fact, the court first decides whether it will even hear the case. If the court declines to hear it, the lower court decision stays in place. If the court accepts it, there will be months of legal arguments, briefings, and careful review. This process does not happen overnight. And during this time, existing TPS protections usually remain active unless specifically paused by a court order. So if you are a TPS holder right now, nothing changes immediately just because a review request was filed. But why does this matter for the broader immigration community? Because Supreme Court decisions create nationwide legal standards. If the court narrows how TPS can be extended, future renewals could become more limited. If the court upholds broader authority, protections could continue under existing interpretation. This is why legal experts, immigration attorneys, and advocacy groups are watching very closely. But again, this is about interpretation of statutory authority. It is not a sudden cancellation of all protections. It is not a mass removal order. It is not a citizenship revocation policy. And in the next part, we're going to talk about something that creates even more confusion: refugee protections and the debate around birthright citizenship in 2026. Because that's where misinformation spreads the fastest. Now let's move to the part that creates the most confusion online: refugee protections and birthright citizenship. First, Refugee protections. Refugees are individuals who were admitted to the United States after proving persecution or fear of serious harm in their home country. Their status is different from TPS. Refugee protection is based on international humanitarian law and U.S. immigration statutes. Recently, some lower federal courts have reviewed policies related to deportation protections and humanitarian safeguards. In some cases, judges temporarily blocked certain enforcement actions while legal challenges continue. That means protections were extended during review, not canceled. But on social media, headlines often say things like, "protections ending," or "mass deportations coming." That is not how the legal process works. Court systems move step by step. Arguments are reviewed, evidence is presented. Decisions are written carefully. Now let's talk about birthright citizenship. This topic always creates strong emotions. Birthright citizenship comes from the 14th Amendment of the U.S. Constitution. It guarantees that anyone born on U.S. soil is a U.S. citizen. Changing that would require either a major Supreme Court reinterpretation or a constitutional amendment. Both options are extremely complex and politically difficult. So when people say citizenship rules are changing, they are often misunderstanding political debate versus legal reality. Right now, there is discussion. There are legal arguments, there are policy debates, but debate does not equal change. And here is something important for your audience to understand. Naturalized citizens, people who legally completed the citizenship process, are protected under federal law. Their citizenship cannot simply be taken away because of a policy disagreement. Revocation requires specific legal proof of fraud during the naturalization process. It is rare, it is case-specific. It is not broad, so why is all of this connected? Because when immigration topics reach the Supreme Court, fear spreads quickly. People assume everything is changing at once. But in reality, these are separate legal questions moving through structured judicial review. In the next part, we're going to focus on the most important question: who is actually affected right now? And what should immigrants realistically do in 2026? Because that's where clarity becomes power. Now let's answer the most important question: who is actually affected right now? First, TPS holders whose protection depends on future court interpretation. If the Supreme Court agrees to hear the case, and if it later narrows how TPS can be extended, future renewals could be impacted. But as of today, there is no automatic cancellation. Second, certain refugee applicants whose cases are connected to ongoing legal challenges. Again, those are case-specific situations, not nationwide sudden changes. Now let's be very clear. Who is not directly affected right now? Naturalized U.S. citizens, green card holders with lawful permanent residence, approved employment-based immigrants, people with valid status who are not part of active litigation. If you fall into those categories, there is no emergency action required today. So what should immigrants do in 2026? Number 1, stay informed through official sources like USCIS and federal court updates. Number 2, avoid social media panic headlines. Number 3, if you are directly impacted, speak with a qualified immigration attorney before making decisions. Immigration law changes through procedure, not rumors. Now let's talk about possible outcomes. The Supreme Court could decline to hear the case. If that happens, lower court decisions remain in place. The court could hear the case and uphold existing protections, or the court could clarify limits on certain extensions. Even in that scenario, implementation would take time. There would be guidance, there would be official notices, there would be transition periods. Nothing in the U.S. legal system happens in secret overnight. And here is the most important message of this entire video. Legal review does not equal policy collapse. Debate does not equal deportation. Court discussion does not equal citizenship removal. The immigration system in 2026 is going through legal clarification, not immediate structural breakdown. If you are living legally in the United States, stay calm, stay updated, and make decisions based on verified information. Fear spreads fast online, but facts move through courts carefully. And we will continue breaking down these updates clearly, without panic, without exaggeration, and without misinformation. Because when it comes to immigration, clarity protects your future. Before we end this discussion, let's zoom out for a moment. Immigration law in the United States has always evolved through court decisions. This is not new. What makes 2026 feel different is how fast information spreads online. Within minutes, a legal filing becomes a viral headline. Within hours, speculation turns into fear. But here's what separates strong communities from anxious ones: accurate information. The Supreme Court reviewing an immigration issue does not mean the system is collapsing. It means the constitutional process is working. Courts review, judges question. Attorneys argue. Decisions are written carefully. That is how the rule of law functions. If you are a TPS holder, stay updated and prepared, but do not panic. If you are a refugee applicant, follow official guidance. If you are a green card holder, your lawful status remains protected. If you are a naturalized citizen, your citizenship remains secure under current federal law. The most dangerous thing right now is misinformation, because fear-based headlines often leave out the legal details. And immigration is always about legal details. In the coming months, we may see updates. We may see arguments presented before the court. We may see legal clarification. But until an official ruling is issued, existing protections remain in place. And even after rulings, there are structured implementation phases. Nothing in federal immigration policy happens instantly without notice. So here's what I encourage you to do. Stay informed, stay calm, verify information, and think long-term. Because immigration decisions should always be made with clarity, not panic. If this breakdown helped you understand what is really happening in 2026, make sure you stay connected. We will continue providing structured, fact-based, professional immigration updates without exaggeration. Because your future, your family, and your legal status deserve clarity. And clarity always wins over fear.